What's up, YouTubers, thrill seekers, ladies and gentlemen, boys and girls, unwanted pets and relatives? It's Mr. Palumbo here. Today we're going to be discussing the third branch of government, a branch that the framers considered to be the least dangerous and not inconsequential, so there's not much written about it in the Constitution. Of course, what I'm referring to is the Supreme Court. Now, there's been a lot of videos out there that talk about the Supreme Court, what they do, how you get involved, who's on. Wake up! Did you zone me out right when I said Supreme Court? I know, my students do that all the time. Look, I know the Supreme Court's not the most exciting thing ever, but you're still watching this video, so you must want to know something about it. So hang in there. You haven't turned off the video yet. I promise you, you will learn something. And remember, I always say the people that are in charge don't want you knowing anything about the government. That way they can take advantage of it. So the fact that you're learning something is good, and you can use that later on. No zoning out from here on in. But what I want to talk about is the original intention of the Supreme Court and where it is found in the Constitution. We like reading the Constitution here at Professor Liberty, so we'll take a look at that. And we'll look at how the evolution or how the court has changed and how this original intention of the Supreme Court might not work so well in today's post-constitutional era. The Supreme Court has turned into this giant monster from like those old 50s movies. That neither one of the other branches can control. And even though in the constructs of the Constitution, these rules that are meant to insulate the judges from the political process and political pressure have really turned it into this uncontrolled and unchecked branch of government. So, if you like monster movies, join me as we go into the Black Lagoon of runaway
judicial activism.
Hey! He got it!
The Supreme Court has been making headlines recently, especially with the passage of conservative Justice Antonin Scalia, which has now led to a vacancy on the court. And it was during an election season where many people voted for Donald Trump simply because of who he would nominate as justice. But with the court's lifetime appointments and their aging justices who seemingly constantly get into political arguments and the political theater, many people are wondering, does the Supreme Court need to change? The Supreme Court has almost always had a favorable and almost revered perception from the American people, but they're not infallible. Korematsu, the Dred Scott case, Plessy versus Ferguson are all examples of extremely bad decisions by a so-called beloved institution that is supposed to be above politics. There's a few things I want you to pick up about the significance of even where the Supreme Court is placed in the Constitution. First of all, it's placed in Article 3. So of the three branches, it's already implied that the Supreme Court would be the least significant. Secondly, this is the third article, and it's also the shortest article. There's only 3 sections, and they're like sentences. I mean, 1, 2, 3 sentences, okay? So basically, there's going to be a Supreme Court. Congress can figure out the other court system. Article 2, these are the kind of cases that the Supreme Court should deal with. And 3, any kind of international law, the Supreme Court should be the one to take care of that. That's it. And so, even in this simple implication the Supreme Court shouldn't be that significant. And yet today, they make all the decisions for everyone. So let's have a quick reading of just Section 1 of Article 3. And as this is being read, think to yourself, what does it mean? But also, this time I want you to think to yourself, is there any inherent superpower in these words that give the court the authority to do what it does today? Which branch do you think is actually the most powerful? We'll be right back.
Article 3. Section 1. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall, at stated times, receive for their services a compensation, which shall not be diminished during their continuance in office.
So what do you think? It's pretty cut and dry, right? I mean, it says there shall be a Supreme Court. It says Congress can figure out how the circuit courts will work and the inferior courts will work. It says a judge will rule as long as he's got good behavior, and we'll talk about that. And then it says you can't mess with his compensation. Now with this good behavior clause, it's simply just saying you can't get rid of the judge unless he does something horribly bad. So he's in there for life. The compensation clause is in there for purely to avoid political reasons. You can't withhold a judge's pay based on if you like him or not, or you didn't like his positions or not. So you can't mess with the judge's pay. And this is tied into the good behavior clause because what the founders and framers were trying to do is insulate the judges from the political process. Let the judges rule unbiasedly. Now, what I'm trying to argue, and others have argued in the past, and I have some of their quotes here today, is this is all fine and dandy, and it was a good intention to insulate these judges so they could be unbiased. But now, today, because of how the court has changed, there's no way to stop these judges when they make a decision that is obviously not constitutional. There is no check or balance on the Supreme Court. Alan B. Morrison, a contributor for the Dallas News, makes this exact point when he says, there is no other Supreme Court in any state or foreign country whose judges have life tenure. Most courts have mandatory retirement ages, or the justices serve for a fixed term. Those courts, he's referring to the lower courts and inferior courts of the United States, were all established in 1787 when our Supreme Court was created. But a great deal has changed in the intervening 230 years, and it no longer looks like such a good idea. Congress, there's checks on Congress with the presidential veto and the courts. There's a check on the executive, which I believe is way too powerful today with the courts and Congress. But there is no check on the Supreme Court. Did I already say that? I think I already said that. But there is no check on the Supreme Court. On the Supreme Court. Court. Joseph Sorbin, a columnist, wrote, "The president can veto any act of Congress. Congress may override his veto, but neither of the other branches has similar control over the court's rulings." Now this is big, guys, because we learned in school that our system is of checks and balances. But it seems here we've got a branch of government that has no check or balance at all. And that's pretty scary.
No.
Writing in Anti-Federalist 15, the infamous Brutus wrote, the Supreme Court under this Constitution would be exalted above all other power in the government and subject to no control. Whew. Good thing that never happened. You guys, this was said even before the Constitution was ratified. Boy, those anti-federalists, if it weren't for them, we wouldn't even have had the Bill of Rights. I want to bring up specifically this political doctrine, this political matters doctrine, or something they call the political question. Now, the political question is a precedent with the Supreme Court where they used to stay out of anything that the Constitution directly gave to the other branches. So if this was a legislative matter or an executive matter, the Supreme Court would stay out of it. It also had to do with social, cultural, or moral issues that the Supreme Court isn't in any position to rule on. These were matters left to the individual states and the people in their states and those political leaders. And today, the Supreme Court has clearly forgotten about this restraint or this restrictive principle of the political question. And they are ruling on everything from contraceptions to marriage to homosexuality to abortion. I think it's fair that if the judicial branch, the Supreme Court and the inferior courts, want to become more of a political branch and dip their toes into all these political, social, and cultural questions, then perhaps their insulation, their political insulation, should also be changed. Because the reason they were insulated in the first place was for them to be unbiased and rule on the law. But if they're going to dabble in cultural engineering, social engineering, and they're going to decide for 320 million people a one-size-fits-all policy, then we need to look at maybe changing or amending the Constitution to make sure we can rein these judges in. I hope you found the video entertaining and informative today. And I know sometimes we can get a little frustrated or hopeless as far as can we return and restore our Constitution to the way it was. And I say we can, but it's going to take lots of people with knowledge, information, and perseverance. So please share this video with others, and together, let's make America... Wait! Don't say it!